We'll start, and there is an important case of Nicaragua case versus US that will be covered today. And on this particular basis, hope this gets clear, and accordingly, we will take up the clarification soon also on this one. Fine. I'll just share my screen. And Tayyab, can you do one thing? Can you make a request that kindly join from institutional ID? It will not require permission to be admitted to this one, right?
Okay, okay, sir. I'm telling.
Please do so. Thanks a lot. Hope you can see my screen. All of you can see the screen?
Yes, sir.
Yes, sir. Yes, sir.
Yes, please. Let's start. And we're discussing about the state responsibility. This is Unit 4. And as we have discussed the role of the state, we're going to be focusing on how far this state's responsibility is being looked into while drawing a contrast with the international law. We have all understood that certainly whenever we talk about the state, the international law and the affairs are being examined. When I say affairs are being examined, we look into that what the state does. State has two functions. One is obligation, second is liability. Now we must understand that what are these obligation and liability. They actually determine and are based purely on the conduct of the state, and this conduct is determined further by international law, where we already have looked into ICJ how things were being looked into, right? So when you look into state responsibility, this way it becomes quite clear, and one of the most important part that it is one of the most important and fundamental principle of international law. This much is clear to all of you. Now let me make an addition. Somebody's coming up. So we come over here that under the international law only, one of the fundamental principle has been coming up, which is looked into it, is state responsibility, and it is purely based on obligations, liabilities, which are arising or determined based on the conduct. And all of us know the conduct is run through and determined on the basis of international law, where we have examined that how it looks into it. Now, question comes up whenever we talk about it, how we determine these responsibility, or what are these responsibilities? Clear? Just a second, please. Whenever we talk about them, how the conduct is determined. So important comes up, the focus is on determining and talking about what are responsibilities. Clear? So these responsibility, whenever we talk about, are one which are regarded on two terms which are very important. These two terms happen to be that how we define the obligations. Second, how we look into these obligations, which if obligations are not fulfilled, will attract the liabilities. These two things have been interpreted under international law through various means. Sometimes, when we look into it, obligations and liabilities through conventions, obligations and liabilities through codification of customs, which we regard as international customs, and these codifications. Then we have also looked into it that what are the orders and the jurists when they come up and their opinions, how they are being regarded. So over here, when you look and examine, these have found out that any unlawful act, whenever we look into it, any unlawful act. Now, question comes up: what is unlawful act? How to determine such unlawful act? Can someone tell me how we determine unlawful act? Please feel free to unmute yourself. When we talk about international relations between states, how do we determine unlawful act? Keep in mind the horizontal nexus and the relation. Yes, please.
Breach of contract.
Breach of contract. Nagesh, when you say breach of contract, which contract are we talking about? Is there any contract under
Like treaties
international law?
between two states.
Come again, Nagesh.
Like treaties between two states.
Yes, you have to say that treaties or agreements between two states, if there is any breach, that same attracts and becomes unlawful act. Important over here is, Nagesh, one thing we must be very clear, and all of you please, that such treaty or agreement should be the outcome of international law. We will not look into any treaties between the states which is not falling within the ambit of ICJ Article 38. Am I clear on this part? Am I clear, all of you?
Yes, sir.
When we look into any unlawful act, another thing that we look over here, it attracts reparation internationally. That has to be looked into. So when we look, a state can incur liability for conduct that may be negligent and that is intentional. Clear? So state, when they can be liable, state is liable in the event when they acted negligently. Secondly, they are liable when such negligence was the outcome of intention being part of it. Though there are two things and theories come up with respect to state responsibilities when we determine object state responsibility and subject state responsibility. On one of the ambit, it has been mentioned clearly that mens rea is not relevant. But necessary to mention over here that intention is to be deduced from the actions that is based on the conduct which has led to such negligence, and such negligency has resulted in a loss to the third state. Am I clear on this part? Please, all of you, any one of you, please unmute, and so that we can look into it, that this is a understanding going on, and if required, I'll explain on that particular points.
Sir, please repeat the second point, sir, of intention, sir. Out
Of
of intention.
intention, one most important thing right now we are talking about the liability of a state as per Article 38 shall arise, and state will be responsible if they have acted or conduct is negligent one. Okay.
Okay,
Secondly,
sir.
this negligence must be deduced that it was done intentionally, right?
Okay.
For example, I am state A, you are state B. Under Article 38, I must inform you that whenever you enter my territorial waters, there are mines being placed. Okay, Tayyab?
Okay, sir.
Now, as a state A, my conduct is proper information which must pass on to Tayyab, who is state B. When I
Yes,
do
sir.
not look into it and Tayyab has incurred into a loss and state B has come up for a loss, in that particular case, important comes up that there is a negligence, right?
Okay.
And secondly, intention being deduced, because when I'm having my relations with the other state, I owe responsibility by virtue of international law. I must inform state B to act diligently or inform them about the mines which are there in my territorial waters. Okay.
Yes, sir.
Now when we look into this particular conduct further, when we examine these ones, it comes up that what are the factors when we determine the responsibility of the state. Remember, we have been talking about that how the state's responsibility is determined or deduced in the present scenario, because we have not only looked into that it is a fundamental principle of international law, but we have also looked into that whenever there is any conduct which is bind under ICJ, and such conduct becomes unlawful because of negligence and intention being involved, which has resulted in a loss to any other state, this will attract reparation internationally. Clear?
Yes, sir.
Now, when we look into responsibility of the state, fine, there are factors to be looked into and to be considered. The factors which are there, that there is an obligation we have been talking about. Such obligation must be recognized under international law. That is why I said, for instance, if state A and state B have obligation arising out of bilateral agreement, and international law is silent on such conduct of both states, what shall be prevailing? For act done negligently, which results in becoming unlawful act, but it is not backed by international law. Yes, all of you? If state A and state B are having an obligation arising out of bilateral agreement, and international law is silent about such conduct of both these states, and a loss to state B occurs, can we hold state A liable under international law?
Yes, sir.
Yes or no?
Yes, sir. We can hold them, sir, liable
How?
because they have, sir, breached the obligation, no, sir. Because they
No,
breached the
there is
agreement.
an obligation, perfectly fine. Most importantly, obligation towards each other, but the same is not backed by international law.
Then on equity, sir.
How will we extend equity? Should I give you a clue, all of you?
Yes, sir. Please.
Go to Article 38 and remember this particular word. Now you will not forget. This is important. What does it say? Can you see the screen or no? Please tell me.
Yes, sir. We can see it.
Now tell me, remember we have always discussed and came across that if any of the state does not give the consent, then in that particular case, jurisdiction of other state cannot be imposed on other states, right? Yes, please tell me. We have done when we were discussing the cases. This is part of the other sources of international law. When we talked about legality and when we talked about asylum and Portugal case requirements of customary law, that it is necessary that other state must consent if they abide by the laws which are to be extended for other country. Can the laws of other country be attracted while deciding a dispute between, for instance, India and other country state B? Unless India agrees and consents to such becoming a part of jurisdiction. Remember, before advisory opinion, when we were discussing, we clearly stated that whatever the outcome is, that is, whenever the opinion of the jurist has been considered or the outcome of the judgments have been, the same cannot be applied directly on each and every case under international law because of its nature being horizontal. Yes, please. Have we done this one or no? Satvik?
Yes, sir.
So, what was the outcome when we discussed? That other state must consent when the foreign jurisdiction is imposed on them, right?
Yes, sir.
So, if the foreign jurisdiction is to be imposed on any other country or country like India as well, why should we submit to such foreign jurisdiction? So, that is why the consent was being made important in this case, right? All of
Yes.
you,
Yes,
Purva,
sir.
Sahil, Puneet, Sakshi, hope all of you are here.
Sir, I'm very sorry to interrupt you, sir. Your screen is not visible, sir.
Yes, I have closed it up so that I can ask that all the
Oh,
students are over here and I am audible to each and every one of you.
okay, sir. Okay.
Is this clear or no? Please tell me.
Clear, sir.
जब तक जब भी हम इंटरनेशनल लॉ की बात करते हैं और जब रिस्पॉन्सिबिलिटी डिटरमाइन करते हैं या कोई प्रोविजन आर्टिकल 38 में एग्रीमेंट कस्टमरी इम्पोज करते हैं और ये कहते हैं कि इट इज़ बाय वर्च्यू ऑफ कस्टमरी लॉ एप्लीकेबल ऑन अदर कंट्री मस्ट ऑल्सो एक्सेप्ट इट. Other countries must also say to this one, and we have discussed in detail the same understanding when we were talking about the case right of passage over Indian territory. Remember Portugal versus India?
Yes,
Yes,
sir.
sir.
जब हम पोर्चुगल वर्सेस इंडिया की बात कर रहे थे तो पोर्चुगल का एक ही कंसेंट था कि यस इट इज बाय वर्च्यू ऑफ कस्टमरी प्रैक्टिस दैट इंडिया मस्ट हैव ऑनर्ड दिस पार्ट. But whereas when it was found out through the agreements, it was clearly stated that India was not under an obligation to provide the safe passage to the army, where the Portugal can actually look into peace and harmony in cases of Daman and Diu. Right?
Yes, sir.
So, shall I go ahead?
Yes, sir. Please.
Now, when we look into state responsibility, most important factor that we were looking over here is most important factor is when we look over here, just give me a second. That there is an obligation which is recognized. This is important line. If the same is not recognized under international law, then it is not an obligation which attracts liability under the international law. Is this line clear to all of you? Second, the act which we are talking about must have been done which violates this obligation. Thirdly, as a result of this violation, there has been a loss which has resulted to any third state. So if we look onto these particular factors, it becomes quite clear that how we are determining or looking into these particular aspects. Now, whenever we talk about further, there are principles where we take help of these principles to decide about state responsibility. The first principle when we look into it is the objective, just give me a second. That we are talking about is objective, clear, state responsibility. When I say objective state responsibility, I clearly say that wrongful conduct must be attributable to state. This is not only defense, but it is also the one which determines liability. Because important is to prove there was a conduct which was wrongful in nature, and it was only because of the actions of other state. Looking into these, when objective state responsibility is seen, fine, they clearly looked into that even if there is no intention or negligence, but even mens rea is irrelevant, but there must have been violation of international law. This is the one which clearly concludes this particular understanding. That violation of international law is seen, we clearly say that it was objective on the state to adhere to such conduct, abide by the rules which have been framed and laid down under international law. When we further look into the second aspect, that is subjective state responsibility. Fine, we have to determine, most important, that what is the jurisdiction of one state over the another state. While determining the jurisdiction of one state over the another state, the necessary element is consent. In absence of consent, there will not be available sovereign immunity. This becomes quite clear that how we are looking into while determining the responsibility of the state. Another part is equality of status. This equality of status amongst the state, clear? Over here, immunity from the suits in the court of another country is being provided, and this is by virtue of Article 2.1 of UN Charter. Is this much clear to all of you?
Yes, sir.
Any confusion still now?
Sir, could you please show this, sir, first objective, sir, objective state responsibility. First principle.
I will just share right now. Just
Okay.
ask any clarification. I will do one thing. I will scroll the entire notepad once, but till now, whatever we discussed is clear.
Yes,
We are
sir, clear.
focusing on state responsibility. That under one conditions, a state is responsible. To determine the same, the conduct is being seen. Such conduct must be mandated under the international law. If the conduct is not backed by international law, then we cannot fix state responsibility on such actions. Clear? So thirdly, we looked into it while determining and looking at the conduct. It must fulfill two criteria which are important. One, such conduct was intentional. Second, Such intentional conduct has been not only done but has resulted in a loss to another state, which was an act of negligence. Is it clear? So
Yes, sir.
when there is a negligence which was done intentional, resulting in a loss to state B, then the state which was negligent is bound to pay or compensate for such act. This is based on two principles, and the factors were very clear for determining conduct, obligations, and violation of obligation under the international law. And when I say conduct, I say that intentional conduct and negligent. That means it has resulted in a loss to another state. This is based on principles. There are two principles when we look into it. One is objective state responsibility under the principle, and another is subjective state responsibility. When we talk about objective, our entire focus is on that state must adhere to international law, where even for no intention, a state responsibility could be attracted. Even for mens rea not being present, still state responsibility could be attracted. Clear? This was objective. The second one is subjective state responsibility. When we say subjective state responsibility, we clearly first of all start with that what is the jurisdiction and under what cases jurisdiction of another state can be imposed on another state. So that means so that states can adhere to other jurisdiction, they must consent to it unless sovereign immunity is being provided. Then we talked about equality of states. Clear? That is immunity from the suits in the court of another jurisdiction that we have looked into. This is all what we have discussed till now. Hope whatever we discussed is clear to all of you.
Yes.
Shall we go ahead?
Yes.
Sir, could you please explain intentional negligence to me? I did not get it.
Okay, Sneha, I'll tell you. When we say that negligence and intention, there are two words which have been used for determining the liability of the state. Okay?
Yes.
When we determine the liability, we only focus on what was the conduct of the state. If the conduct is attributable to two factors, where one is negligence and other is intentional, that the conduct was not only negligent but also intentional, in that case state will be liable for compensation. Clear?
So the conduct has to be negligent as well as intentional at the same time.
Yes.
Okay, sir.
And both of them, Sneha, are actually being attributable to only one thing, that is obligation of all the states when they are signatory towards other state, that all of them have responsibility towards other state, and this responsibility is understood as they all have obligations towards another state. Clear?
Yes, sir.
Now important thing is, when will this state be not liable? The state will not be liable in cases where their conduct, first of all, is not covered within international law. That means there is a bilateral agreement. Remember, I just provided this particular example. If you see, I'll again highlight this particular example.
Yes, sir.
Pay attention to this example. State A and state B have come across a bilateral agreement, and out of bilateral agreement there are obligations which are arising towards each other. Important thing is, this bilateral agreement is not backed by international law. Clear? Now state B says that it was the action of state A that they are responsible because of their conduct, they were negligent and it was done intentionally. Can international law answer this one? Tayyab answered yes. When Tayyab said yes, he may be having in his mind that it may be falling within the ambit of customary law. Then I gave the example of India versus
Portugal.
Portuguese, right? That was the Portugal versus India case, where despite it was a written, despite it was a customary practice which was being shown, the outcome came up unless the country consents to being followed or accepts the jurisdiction of other country, it will not be made a compulsion. International law cannot be imposed on any other country. We know this thing. Only Article 38 could be excised for determining the roles and responsibilities, right?
Yes, sir.
So on that particular basis, when we come up, the principle is based on two aspects. The two aspects that we discussed are one, objective state responsibility, which only says if you are a signatory to international law, you will be for no intention, and even when the mens rea is not there or no negligence, you will still be liable in certain cases. And those certain cases was that wrongful conduct by a member country has been done which is attributable to the state. Is it clear?
Yes, sir.
It's moreover like no fault liability. Remember that one?
Yes, sir.
Fine. So this is one. The second one is subjective. Then we talk about subjective. The jurisdiction is being looked into. That when the jurisdiction will be looked into and when the country will be subject. Because remember, we have been talking about that if a dispute arose out of state A and state B, that which jurisdiction shall be subjected. The answer which has been coming up under international law is unless state B or state A consents to it, their jurisdiction of another state cannot be imposed on other country, right?
Yes, sir.
Or should I repeat this one? If
No.
there is, okay, I'll come across this one. If the issue has come up, for instance, India and Pakistan, we say that, okay, fine, Pakistan must be subject to Indian law. Will they agree to it?
Not really, sir. No.
They will not. Actually, despite being signatory to UN and even being abiding by ICJ, they will not say it. And same ways, vice versa. If Pakistan says India must adhere to the laws of Pakistan, they cannot do it, right?
Yes, sir.
So now give me an answer. Under what condition? Whether the laws of Pakistan or laws of India could be extended or imposed on other state. Only when
Sir,
such
when the
state consents to it, right?
yes, sir. Yes,
And when the state consents to it, where is the protection being provided? Article 38, and we call it as a customary practice,
Yes.
right? That is how you're going to be extending it up. Else, where will you take up? What are the ingredients of Article 38 ICJ? Someone please tell me.
हाँ हमने आरओ की क्लास चल रही है.
Can someone tell me what are the ingredients of Article 38?
Yes, sir.
Yes. First is convention.
International Convention.
Convention.
Yes,
Then,
Purva,
sir, we have
second.
customs, sir.
Second is?
Then we have international customs, sir.
Yes. Then third?
General principles of law recognized by civilized nations.
Yes. And fourth?
And judicial decisions, sir.
Opinion
And
of the
this is
jurist.
so-
Tayyab?
Yes, sir. Yes, sir.
Opinion of the jurist. So
Yes.
this is all something coming up because today we are discussing that under what conditions state responsibility could be extended to other countries as well, or when the state itself will be liable. So we are going by discussing and balancing out both the discussions, right? Should I continue further? This much is clear to all of you.
Yes, sir.
Now we are looking into this particular aspect. that there is Article 2.1 of UN Charter, which clearly talks about the principle of sovereign equality of all its members. You know what this principle is being used for? It clearly says that all the states are equal, and hence no law or jurisdiction of one state could be extended beyond its territorial jurisdiction to regulate or to cover up or to decide the dispute between two states. Because of this, we come across that what is this sovereign immunity and when is it extended to others. This sovereign immunity could be extended and it's only to be considered, first of all, to the states under UN Charter, to the head of the state, then thirdly, agencies which are conducting state business. What does it say? If there is a, we can call it up, diplomatic relations between India and Pakistan, Indian embassy in Pakistan is, by virtue of this sovereign immunity, which is outcome of UN Charter, is seeking protection. That despite the relations being worsened or even the warlike situation between state A and state B, the protection will be given to the states, head of the states, and agencies conducting the business. Important thing when we look into it, if the war breaks out, that means there is no longer a relations which could be seen in that particular case. All of them, moment the war breaks out between two states, head of the state and all of them agencies are left without the UN Charter, and there is no protection we can be looked into. In this scenario, when we look into sovereign immunity, we also cover up that there are defenses which are available. What are these defenses when we look into, which are given to state or available while determining their responsibility? Defenses are that we do not consent to the jurisdiction first, but they must show in this light either an agreement or as a customary practice or general principles of law or through opinion of the jurist. Clear? So when you look into it, secondly, the conduct was not negligent and same was either unintentional. Thirdly, international law is not applicable. Hence, there is no violation of international principles. When we look into it, it was under Corfu Channel case. In Corfu Channel case, diplomatic and consular case is, we call it as well. In this one, most important thing, it was held that Iran was responsible because of omission to act. Important thing, the responsibility of Iran was determined because Iran was not able to extend to the agencies conducting their business any protection while looking into Corfu Channel. What was it? What was it all about? There was Albanian was responsible because it should have known about the presence of the mine in its territorial water, and they failed to inform the third state about it, which has resulted as a consequence the loss. And because of this particular loss, they held before the ICJ that there is a loss which has come up to them and they were actually claiming it. Now, when we look, there is another important case when we examine. This is, hope all of you can have a look at it.
Yes.
I've shared it as well. All of you can see this particular page. We are talking about Nicaragua versus State of America. Now, when we talk about Nicaragua, the important thing is that we are talking about state responsibility, attribution, and constituent elements of custom as well. Because remember Article 38, second part, that whether there was an element of custom being present into it, and also how these customary rules have been applied. The dispute has come up between Nicaragua and United States. When we look into this particular one, what happened in United States had excised control and had looked into it, facilitated Nicaragua with the fall of the government. When the government in Nicaragua had fallen, US provided aids and they also looked into facilitation through finances and also being provided other things. There was a government which was being formed, that was Junta of National Reconstruction, an 18-member government which was installed the body and had led to the armed opposition of President Somza. Fine, and this was FSLN. This government was formed, and when determining the attitude, this is important because there are paras from the case itself. The attitude of the US government to the democratic coalition of the government was first favorable. It is most important that initially they found it favorable and they actually came up with the programs to aid Nicaragua. But in 1981, the attitude changed. This is again being looked into it, that in 1981, the attitude of US changed and such programs, these programs were suspended from January 1981 and terminated in April 1981. While looking further on these, when these two were coming up, there were reports of involvement of government of Nicaragua in logistical support, including provisions of arms for guerrillas and El Salvador. So this was being coming up when they were being examining. That means initially the government of Nicaragua fell, US started coming, facilitating them through economic and other policies which were being imposed. And when these were coming up, when Nicaragua's action was that they came up with the provisions of arms and also guerrillas in El Salvador, that was a warlike situation, then they had withdrew themselves. Most importantly, when they withdrew, there was no interruption till that time. Important is that there was no interruption till that time in diplomatic relations. Now, important is the armed opposition had come up and a new government in Nicaragua, which was comprising of various movements, had come up. Anyhow, till now, there is no issues which are coming up or emerging. Clear? But when they looked into these particular one, there were events which were coming up. These events were out of the revolts which were being seen. They started with initially the first. They grew from 1981 with trained fighting forces and started operating. Whereas second, they formed in 1982 and started operating on the borders of Costa Rica. Now this became the concern that how Nicaragua receiving the aid and facility from US starting carrying out its operations in these ones. Now when they looked into it, the precise extent to which and a manner in which US government contributed to bringing about these developments was studied closely and later in present judgment. However, when we consider in these ones, there was clearly the covert operations of US personnel and persons in they were becoming part of the public knowledge. They made it clear that United States has actually taken these actions specifically to support the Contras, who did not wanted the government to function over there, and US has been doing it intentionally. And further, in 1983, with the budgetary legislation enacted that US Congress and the provisions of fund to be used by US intelligence agencies for supporting directly or indirectly paramilitary operations in Nicaragua. Now they are actually coming up and supporting Contras was the allegations by Nicaragua, while determining that US is responsible. Instead of coming with the support to the government, they have come up with the Contra operations, which have caused considerable damage to them and widespread loss of life and also killing of the prisoners over there. While looking into further, they examined that there were actions like civilians, torture, rape, and other things being coming up, and effectively the US government was controlling the Contras. This is here. It was that US government was effectively in control of the Contras, and Contras were the ones who were torturing civilians, rape, kidnapping, and these actions were being coming up. Now, most important difficulties in the present scenario which were being looked into it was, firstly, that there is a marked disagreement between the parties and the interpretation of the fact that US has actually led to such a situation. Secondly, the respondent state has not appeared during the present merits phase and the proceedings were deprived before the court. Thirdly, there is a secrecy in which some of the conduct attributable to one or the other parties has been carried on. Important thing comes up, it was difficult for the courts to look into it, that what were the facts, whether these were the acts, though there was a lack of evidence when they look into it clearly, that what were the facts when they looked into it, what were the evidences when they were being examining, and how they were being looking into it. It was through this that lack of evidences, and the problem is not the legal process of imputing to a particular state but establishing responsibility. Further, they examined this one, that the present court has to endeavor the first to establish actually what happened, and they looked into this particular scenario. Para 80, when they looked into it, they established clearly that President of US has authorized US state government agencies to lay mines in Nicaraguan ports. Important thing, US is laying mines in Nicaraguan ports, and this has resulted in loss and injury to Nicaragua. Hence, US is responsible was the another one which was coming up. Clear? And hence, when they look into this particular scenario, there was being looked into that neither before laying mines nor subsequently did US government issue any public or official warning to the international shipping and existing location of the mines that the persons and material injury was caused by the explosion of mines, which also created risk of rise in marine insurance rates. So this became again an understanding that how they were being looking into it. For the present case, the court finds that the incident of overflights causing sonic booms in November 1984, this is in 1981 April, US has withdrew it. Now Nicaragua is putting it across very clearly that even in 1984 there was a public knowledge that sonic booms were being heard, and that was because of overflights which had caused. Now looking into another aspect, fine, and examining, it was the responsibility that whatever other responsibilities of US may have incurred in the latter respect, violations of Nicaragua airspace, which court finds imputable to US on the basis of evidence before it, attitude to reconnaissance flights, and secondly low altitude flights from 7 to 11 1984, which were complained of causing sonic booms. these things we clearly came up, and these were the matters which the court was being examining. Now they are actually coming with all the issues in para 9906, that what were the things and actions of one another being examined. Then when we go directly to the issues, there have been on para 122. Para 122, the court is concluding on that particular understanding that an agency of US government supplied to FDN a manual psychological guerrilla warfare, which was supplied to the Contras as per Nicaragua. And the court is concluding that on the basis of the evidences, while expressing discouraging indiscriminate violence against the civilian, considered possible necessity of shooting civilians who attempted to leave the town, and the text was supplied to the Contras and advice of use of professional criminals to perform unspecified jobs. Hence, when they looked into this particular one, there are other findings of the court like para 83, 183. The court came up to the conclusion that the next to consider are what are the rules of customary international law to the present dispute, and how can we extend that one, because agreements between US and Nicaragua has ceased to exist and US has withdrawn, so automatically they came to the international customary principle in the present state, that what could be seen. So they directed the attention and they looked into the practices for customary. Also another important factor is opinion of the juris state. Remember, this is also the considered element that we look into it. On these bases, when we look, there is a degree of agreement between the parties. That is the first thing. Fine. Then we determine whether the degree of agreement is in non-use or force or has been intervened by any way. Then we look into it. The recognition given to such agreement, whether that is sufficient to exist or has actually refused to be in force. Then we look into Article 38, that what is the general practice of law which is to be looked into. This entire one, when we examine, they look into that while determining the customary, the substance of the customary rules relating to the use of the force in international relation applicable to the dispute must be seen. They also looked into that there was an example that the principle of non-use of force, for example, must be regarded as principle of customary law. They are coming and deducing that it is not necessarily that customary law could be interpreted otherwise, but even the silence was given an interpretation in the present case. Hence, they looked into and backed by Article 43 of the Charter, which clearly stated, therefore, seem apparent that the attitude referred to express opinion juris respecting to such rules henceforth be separately from the provision of especially those of institution kind. Para 202, when they look into it, hope I'm not going that fast. Yes, all of you?
Yes, sir.
Okay, I'll continue. I'll just go for the important part. In 202, they clearly said the principle of non-intervention involving the right of every sovereign state to conduct its affair without outside interference, and they have given the examples. Para 227, they clearly talked about what is unlawful in accordance with that principle in recourse to the threat and territorial integrity of political independence of the state. They looked into para 2 to 239 and they talked about that application, the present one, that is principle of non-intervention. Fine. And its affairs, that is military and paramilitary activities which were being conducted by the US in Nicaragua. They looked into A part and B part, which talked about actual overthrow of the existing lawful government of Nicaragua and its replacement by the new government acceptable to US. This is important because it was talked about acceptable to US and the substantial damaging economy which has come up. So accordingly, in para 242, the court therefore finds support by the United States up for the end of 1984 September that military and paramilitary activities of the Contras in Nicaragua and financial support was being provided And accordingly, they clearly said that the principle of non-intervention is being at a breach. And accordingly, in the present case, when they looked into it, the court had clearly found that the respondent has, by activities in relation to the applicant, violated number of principles of customary international law. That means they clearly established this particular principle one, and they, as per Article 33, they enshrined, indicated a number of peaceful means which are available. This principle has also status of customary law, and hence, in present case, the court has taken a note in order to indicating provision measures in its judgment on jurisdiction and of admissibility. So they clearly came up on this particular aspect and they concluded. Hope this is clear.
Yes, sir.
I'll do one thing. There are reference readings which I have shared. All of you have access to the Google Classroom.
Yes.
I have shared some material today. Hope you, all of you have access to that one. All of you have seen or no?
Yes, sir.
If not, I'll just show you one so that you see, because this is what I have already in the morning only come across and shared. This is the case. No, this is the content of state responsibility, right? And then I have, this is what I discussed today. All the principles of state, right? And then I talked about the Corfu Channel, and thereafter I started with Nicaragua case. This I have already posted up. I request that for your queries, you kindly mention it in the Google Classroom. I will look into that particular aspect, and all these clarifications, I'll do one thing, I'll take it up tomorrow, right? Because I have actually done Nicaragua case that is provided. Kindly read Corfu Channel case, Barcelona, and case concerning US diplomatic and consular staff, though that will also be covered in the last topic, and that is under sovereign diplomatic and consular immunity privileges. The case will be coming up. Clear? And secondly, when we look to other one, that is the theories, I'll take it up another case tomorrow, and La Grande case, that is Germany versus US, and close it up this unit 4, right? So tomorrow I'll be closing up unit 4. Hope this is convenient time for all.
Yes, sir.
Yes, sir.
So tomorrow we meet up again, because I'm on medical leave, and I'm not keeping well with respect to one eye that has been swollen. So that is why the doctor has asked me to just give rest, so I cannot come over there. And accordingly, we'll start with then by tomorrow only. I'll try to introduce law of C. So I request all of you kindly read this particular case and La Grande case also, and I'll talk about the rules of attribution till that time. And also will pass a reference to elements of international responsibility, which I've done right now. I'll pass it again a reference. And tomorrow we start with the law of C, because by this week I prefer to complete law of C, and accordingly tutorial classes I'll be taking up the confusions with respect to topic 4 and topic 5, because we have topic 5, topic 6, and topic 7 talks about sovereign diplomatic consular immunity. That will be a shorter one, and same is with respect to state jurisdiction. Both of them I'll try to wind it up in 2 hours, but law of C will be taking little time. So hopefully we'll be able to wind up before September 8th. I believe September 8th is the last day, na?
Yes, sir. Last working day, sir.
Last working day. So we'll be able to complete this labor. Don't you worry about that one, right?
And please also discuss, sir, PYQ, sir. Please, sir.
Yes, Tayyab, come again.
Sir, I was saying you please discuss PYQ also, sir. Previous year question paper.
That
How
I'll be
to
discussing.
answer, sir.
I'll be discussing. I'll be also talking about, because remember initially we have discussed from topic 1. If you look into it, let me just share. And I believe today is the maximum strength in my class. I'm happy to know about this one, because
All
at a
thanks
convenient,
to live class, sir.
No, we cannot say online class because it has little things I would not have taken up, but I got a little bit. I was left with no other option. That is why I came up. Anyhow, when we look across this one, all of you, can you see it? Initially, we discussed the international law. We talked about the jurisprudential theories, codification. Important focus was codification. I asked in the class to go for a 20-mark question and answer writing format, and also the definition of international law. Hope that was clear to all of you.
Yes.
We talked about then sanctions and subjects of international law. Remember this case we talked about? Reparation for injuries suffered in the services of the UN case that usually they do not have anything. The states actually send their servicemen, armies at the service of UN. So till the time there is a compensation which UN can impose against such state which has acted or on whose actions the loss of life has been suffered or injuries have been sustained by persons who were tendering the services to UN. Remember this one? I've given two questions from this particular topic. That when we
Yes,
talk
sir.
about, then we talked about sources of international law. Again, there were two questions we came across. We discussed France versus Turkey. Which law shall prevail? And while talking about sources, we looked into Article 38 in detail. We talked about right of passage over Indian territory, that is Portugal versus India, in detail. Asylum case, I went for self-study. Then general principle recognized, and also advisory opinion, we have done that one. That yes, advisory opinion could be extended. And in a case, we were looking into it whether ICJ is superior or it is the General Assembly which is superior. Remember that one? We have done this one over here. This was under the resolution of General Assembly. Fine. And then we talked about advisory opinions as well. And the cases we have done on this one was in accordance with the international law. And we talked about these. And I think in this unit 2, I gave sources of international law. We discussed codification. We passed a reference, opinio juris, general law applicability. This was being discussed in this one. And topic 3, we have done Berubari Union, right? Ramkishore Sen. Then I discussed in the class Vellore Citizen, Visakha, and Kulagadam Chetiyar case. This we have done in the class. Remember? Based on
Yes,
two theories. And thereafter, today we have discussed in topic 4, state responsibilities, the clear understanding of Nicaragua case. We're going to be discussing about the theories and try to wind it up. Lagrange case tomorrow, and then we're going to start with law of sea. Clear?
okay, sir.
And previous year question papers as well I will discuss, and I will also post questions which you will attend, so that we can focus on the answer writing as well, which was a concern for some of the students, right?
Yes, sir.
Fine. So we meet tomorrow. I will share the link and inform Tayyab accordingly, right? Is
Yes.
anybody having an objection to this particular one? All of you are comfortable with the class at this moment? Yes, Nidhi, Raj, Abhishek, Harshit.
No,
Anyone?
sir, no problem.
Yes,
No
Nidhi,
problem.
Nidhi, is there a problem for you?
No, sir.
You wrote yes, sir, or no, sir?
No, sir.
Okay, fine. Then we meet tomorrow at the same time, right?
okay, sir.
Okay.
Okay, sir.
Thank you, everyone. Thank you for your cooperation and understanding.
Thank you, sir.
Thank you.
So
Thank you, everyone.